Hey everybody, for tonight's video I wanted to talk a little bit about the back and forth that has been going on between the defense and the prosecution in regards to the investigative genetic genealogy that the FBI utilized in their investigation into the Idaho 4 murders. The defense has really been pushing on the IgG topic for months now. Early on in the case, the prosecution was stating that they weren't going to be using any of the IgG evidence at trial. They didn't use any of that in obtaining the arrest warrant for Bryan, and they didn't use it to get the warrant for his DNA. They're saying that the IgG investigation was simply a tip from the FBI that helped support the case overall in their follow-up and in identifying Bryan Kohberger. So essentially what they're saying is, on one side over here, the FBI was conducting their investigation, building the family tree, kind of looking into the DNA from the knife sheath, trying to figure out who the person could be and get a clue. And at the same time over here, the local police were continuing to look at video footage and try to kind of figure out the case at the same time. And so these two things eventually merge together, right? And you have their investigation and you have the FBI's investigation coming together. So the defense early on was requesting certain discovery around the family tree and things like that, and the prosecution was, at the beginning saying, oh, you don't need any of that, we're not going to be using it at trial. Well, there were some closed hearings, and then the defense was granted visibility into some of that discovery that they were requesting. Now both sides agree that things like the family tree, anybody who was identified individually through that investigation, is obviously not going to be disclosed to the public. And so these recent court filings referencing some previous cases that got me thinking about the affidavit and some of the things that stood out to me early on in the case that just didn't feel normal. And now seeing these recent filings from the defense, it's got me thinking of another theory on what I think the defense might be going after with this pursuit of the IgG information. So remember earlier too, the defense was wanting to get the trial moved to another county, claiming that, the jury pool could be tainted and biased toward Bryan. Well, now all of a sudden what they're doing in these recent court filings is they're wanting to have more visibility on things. So it's almost like they lost that battle, and so now they're moving on to the next battle. And in this case, more visibility they feel is going to benefit them versus everything being under seal. So in my opinion, there is something here that they're going after specifically. It could be a couple of things, but I do think that there's a purpose behind this. For example, if we look at this first filing here from the defense, it's the motion to unseal parts of IgG materials. So what they're saying here is they want to unseal more of the IgG investigation. They understand, though, that they're not going to be unsealing the family tree or any names. That's not what they're requesting here. They have the same concern about individuals on the family tree being identified. But what they do object to is the sealing of the rest of the information that has been disclosed. So they've found some sort of information there that they want the public to be able to see. They want it unsealed. They say there is simply no legitimate reason that the way the IgG procedures in the case took place should be shielded from the public. So it sounds to me like they're targeting some sort of violation here or breakdown in the investigation that was, maybe a violation of Bryan's rights or a violation in the way the IgG data was used or the family tree and that information was obtained. Their next filing goes on to say something similar, and it says, this is the objection to the state's motion to close hearings. So there was a hearing scheduled for this week on May 14th that was rescheduled to the end of this month, but the prosecution was wanting that May 14th hearing to be closed. The defense is pushing back on that, and they're saying the process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. So they're implying here that the FBI and law enforcement is hiding something, right? They're not saying that, there's a delay or something like that. They're saying that there's a clear violation of something happening here in the way the IgG data was used. And then they also are referencing here that if they don't get this unsealed, that would be a violation of Bryan's rights in regards to a public trial. It's kind of two pieces here. It's one, we want this information to be unsealed, and if it's not then that would be a violation of his right to a public trial. So they're wanting to shine a light onto something here that they know about that was disclosed to them in regards to the IGG investigation. So I do think that there is something here that the defense is going after, where the FBI may have mishandled the IGG investigation in some way. Now, law enforcement does have documentation available that breaks down the guidelines in regards to how IGG data can be used and certain rules on how that evidence has to be handled throughout an investigation. Also, it outlines when IGG can be used. So, for example, they don't want to all of a sudden just take people's DNA and start running that through systems. That would be a violation of people's rights. So they use this type of investigation very sparingly, and it's typically unsolved violent crimes. So the Idaho 4 case would definitely meet that criteria as far as reasoning behind why they took this approach and utilized the DNA the way that they did. So another example, though, is investigative agencies have to identify themselves as law enforcement to the services that they're using, and they have to search profiles only in those GG services that provide explicit notice to their service users and the public that law enforcement may use their service sites to investigate crimes or to identify unidentified human remains. So these services that the law enforcement is using to investigate using the IGG data, they have to tell their other users that could happen, and those people have to opt in. This also states multiple times that you cannot use the findings from an IGG investigation solely to arrest a suspect. You have to still have other supporting evidence, direct DNA matching to, the crime in some other way. You can't just use this to obtain an arrest warrant or to obtain a warrant for somebody's DNA. This is simply something that law enforcement is supposed to use as a lead. So like I said at the beginning of the video, it wasn't an accident that the IGG part of the investigation was left out of the affidavit and left out of everything that they were using to obtain those warrants. They are very aware that they cannot use the IGG data for those reasons. However, if the defense is aware of something that law enforcement did that they shouldn't have done, it's not going to prove Bryan's innocence, but it could get him one step closer to getting other evidence thrown out or not being allowed to be used by the prosecution. The thing that the defense has to really get around is that direct match of DNA from the knife sheath to Bryan, right? So the warrant where they were allowed to obtain Bryan's DNA directly and compare that to the knife sheath is really the nail in the coffin, in my opinion, for Bryan. So that is something critical for them to try to either discredit or get inadmissible in some way. So in order to do that, you have to get ahead of the case, right? You have to get earlier on in the investigation, and you have to find something that you can cut off that basically breaks down how they got to that point in their investigation. So there could be something, again, that they're aware of that the FBI did. So this next document is really interesting, and this is the one that led me back to the affidavit and that thing that I noticed early on in the case that just didn't sit right with me. But this is the defendant's response to the state's motion to limit testimony. The state was, again, requesting to limit testimony on this matter because they're claiming the IGG data is not going to be used in the trial. It wasn't used to obtain the warrant, and so they're kind of trying to, limit the pursuit of that. Well, the defense is coming back and they're, objecting to that. And what they're saying here is the state cites no authority for this claim. Mr. Kohberger has the ability to challenge the probable cause affidavits in this matter that were used to procure warrants. So, like I said, they've got to get ahead of the warrants that obtained his DNA, and they've got to find a way to get around that. And so what they're doing here is they're going to go back and they're going to challenge the affidavit. And if they can find anything early on in the case that broke down or that is a violation, that can hopefully lead them to a way to get that warrant for his DNA thrown out or excluded, that's good for them. And the reason I think of that is because these cases that they're referencing here, so if we look at the State versus Hosey, law enforcement was given a tip by an informant about a vehicle that was transporting drugs. And so law enforcement used that tip, i.e. IgG data, right, is a tip or a lead or an informant. So in this case, law enforcement, in this case that they're referencing here, had an informant who gave a tip to law enforcement, who then pulled somebody over, ended up searching the vehicle and found drugs, and that person was arrested. Well, what they did is they challenged the credibility of the informant. So same idea in this case. They wanted to get ahead of the probable cause. They had to stop the car initially. So if they can discredit that confidential informant, then they could potentially find a way to block, that first step that law enforcement took to, make contact with that person. So it feels like, they're referencing these past cases in a way that maybe they're trying to find something in the affidavit that violated Bryan's rights in the initial way law enforcement identified him. So that brings us to the affidavit and what I wanted to tell you about that I think the defense might be targeting with some of this IgG investigation. So the very first part of the affidavit that actually mentions Bryan Kohberger is the part here where it says on November 25th, MPD asked area law enforcement agencies to be on the lookout for white Hyundai Elantras in the area. Okay, so that was on the 25th. 4 days later, on November 29th, at approximately 12:28 in the morning, WSU police officer Daniel Tiengo queried white Elantras registered at WSU. So he's taking some sort of action here at 12:28 in the morning. 4 days after, the law enforcement asked everybody to be on a lookout for the white Elantra. So for whatever reason, for the first 4 days, he didn't think of doing this, right? So on the fourth day at 12:28, this officer decided to query for white Elantras at WSU. So as a result of that query, he located a 2015 Elantra with Pennsylvania plates registered to Bryan Kohberger, residing at 1630. So then, interestingly enough, it says that same day at approximately 12:58, WSU Officer Whitman was looking for white Elantras and located a 2015 Elantra at that same address. So it doesn't say, that Officer Tiengo called Officer Whitman and said, hey, I just ran this and here's the address, go check it out. This was two independent things that just happened within 30 minutes of each other. Two different officers were pinging right on Bryan Kohberger. And this felt very weird to me early on when I read through the affidavit. This felt, the timing here, remember, it doesn't say when the FBI gave the tip to law enforcement on who Bryan Kohberger was. And this is the first reference of tying Bryan Kohberger to the white Elantra. So what they did is they found the vehicle, they ran it, Bryan came up, they saw the description was the same as the eyewitness, and then from there they claim they started pursuing Bryan Kohberger and his phone and the video and putting all of that together. But again, this day, this whole, the 4-day window, but before they actually, I would almost think that if on November 26th they released this alert, the very next day officers would be, looking into these things. But for whatever reason, 4 days later, within a 30-minute window, we had two officers discovering Bryan Kohberger. So it does make me wonder if there's a possibility that the FBI tipped off local law enforcement in a way, that ties in with the actual affidavit, and it's just being excluded. So we know that they're excluding the IgG piece on purpose, but if the defense can find a way to prove that the IgG data somehow caused law enforcement to be prejudiced against Bryan, and that led to everything else down the hill, probably their best bet in regards to getting rid of the DNA evidence. They've got to find some sort of violation there where that evidence will be excluded. Because I don't think they're going to find any experts on their side that's going to discredit the actual DNA from the knife sheath matching Bryan's DNA. So they've got to find a way to prove some sort of other violation. Thank you for watching True Crime Time.